You moved out. You cleaned everything. You handed back the keys. And then your landlord sends you a deposit return that is barely half of what you put in. Sound familiar? Before you assume you just have to accept it, you need to know this: landlords cannot legally deduct whatever they want from your security deposit. And millions of renters lose money every year simply because they do not know the rules. Today we are breaking down exactly what landlords are and are not allowed to take from your deposit. This is information that could put real money back in your pocket. So let us get into it. First, let us get clear on what a security deposit is and what it is not. A security deposit is money you pay up front that your landlord holds during your tenancy. It is not a fee. It is not a gift. It is your money. And under the law, it is refundable. It is against the law for a landlord to collect a non-refundable security deposit. Virtually all states require that your deposit be returned to you after your tenancy ends, minus only specific lawful deductions. So if your landlord ever told you that part of your deposit is just non-refundable, that is a red flag. That language likely has no legal standing. Now, landlords do have a deadline to return that money. That deadline is not the same everywhere. Security deposit laws vary significantly by state. In some states, landlords have as few as 72 hours to return your deposit after your tenancy ends. In others, that window stretches to 1,080 hours or more. The key thing to know is that there is always a legal deadline. Your landlord cannot just hold onto your money indefinitely. Let us talk about what landlords are actually allowed to take from your deposit. There are legitimate deductions, and you should know them so you can tell the difference between a lawful charge and an illegal one. Landlords can deduct for unpaid rent. If you owe rent when you leave, they can take it from your deposit. They can also deduct for damage that goes beyond normal use of the property. We are talking about things like a hole punched in a wall, a broken window, or severe staining that was not there when you moved in. Landlords can also deduct for unauthorized alterations. If you painted a room a different color without permission or installed something without approval, that may be fair game. And they can charge for cleaning costs that go above and beyond what would be considered normal, meaning if you left the place in a genuinely dirty condition that required significant work to restore. Those are the categories. Anything outside of them starts getting into legally questionable territory. Here is where most renters get taken advantage of. Landlords cannot deduct for normal wear and tear. This is a legal concept that means the natural, gradual deterioration of a property through ordinary use. If you lived somewhere for 2 years, things are going to show some signs of use. That is expected. That is normal. And the law protects you from being charged for it. What counts as normal wear and tear? Minor scuffs on walls, faded paint, carpet that is worn down from just walking on it every day. These are things that happen when a person simply lives in a space. Landlords cannot withhold any portion of your deposit to cover repairs caused by normal wear and tear. That is not a gray area. That is the law. Let us talk about painting specifically, because this is one of the most common ways landlords try to take money they're not entitled to. Landlords cannot deduct painting costs for basic maintenance. Repainting walls after a tenant moves out is considered a routine landlord responsibility. They can only deduct for painting if you painted over the original color without permission or if you actually damaged the walls. And in most states, painting is considered normal wear and tear after 2 to 3 years. So if you lived in a place for 3 years and the walls look a little tired, that is not your bill to pay. Carpet is another big one. Many renters assume they will automatically be charged for carpet cleaning or replacement when they leave. That is not accurate. In most states, landlords can only charge for carpet cleaning if the carpet was professionally cleaned before you moved in, or if the carpet is significantly dirtier than what normal use would cause. If you lived there and used the carpet the way a normal person uses carpet, you generally should not be on the hook for it. Here is one more thing that is critically important for anyone with a service animal or an emotional support animal. The Federal Fair Housing Act is very clear on this. Landlords are prohibited from charging pet deposits or pet fees for service animals or emotional support animals. Full stop. This is federal law. It is not optional. It does not vary by state. If a landlord tries to charge you a pet fee or require a pet deposit for your service animal or emotional support animal, that is a fair housing violation. Let us put this all together with a real scenario. Say you rented an apartment for 3 years. When you move out, your landlord sends you a deduction list that includes repainting all the rooms, a carpet cleaning fee, and a general wear and tear repair charge. Based on everything we just covered, all 3 of those deductions are legally questionable. The repainting is a maintenance cost, and in most states, after 2 to 3 years it is fully the landlord's responsibility. The carpet cleaning would only be valid under specific conditions. And wear and tear repairs simply cannot be deducted under the law. You would have a strong case to dispute every one of those charges. Now you know the law. Hit like, subscribe, and share this with someone who needs to hear it. And drop a comment below with the legal situation you want us to break down next. The law affects every part of your life, and you might as well know how it works. Knowledge is the one thing they cannot take from you. See you in the next episode of Know the Law.